in reading week, I started doing some weapons and I started looking up and typed out the
No, I didn't because I hadn't talked to her. My friend was like, oh, we want to take the train, and I was like, oh. No, it's not. It's a good question. Hopefully not. They just don't know. I was looking at a map.
It was Outlet 2019.
And those are my 40 credit modules. Like I have my two home year exams in the same week. Then on the 7th, but then I have a whole week for corporate governance on the 15th. So that's like I know I want to start studying corporate governance on like I want to start on
Monday. For me, it's like
so I am before
we have the private equity 3 days. Until they, and then so that's from the but they all know the same. Do you have any plans on attending incredibly accessible, so it's all divided up into different sections. You have a really good intake stage, and then basically just learn where some people are just
the night before I had 7 o'clock in the morning, I spent the whole night editing and recording.
you just know, like, basically what I feel like I can also do this. I thought I was going to be late. I'm going to go back and forth because I need some writing on my station. I need some data sources as well. And I don't expect to be making even the I have some certain things that I
Yeah. So we today we talk about debt finance um, from a sort of corporate law perspective. Debt finance is at least from a typical orthodox corporate law perspective, debt finance is, in a sense, outside the usual corporate law framework, for the simple reason that when you enter into a debt relationship with a company, you have rights against the company, not rights in the company. So the shareholders are party to what we call the Section 33 contract, but not creditors. So essentially, company law focuses on the shareholders. But one reason why company law has traditionally looked, I suppose two reasons, why company law has traditionally been interested in debt finance is to do with a type of security that English law has recognized as relevant, and that type of security raises issues that most company lawyers will be interested in. By this I mean the floating charge. So essentially, this raises particular issues of interest for company law. But and that's more of a doctrinal thing, because another reason why we would be interested would be, as a matter of practical reality, we know that the company's source of financing, due to the positive advantages of leverage, would be debt finance. So, I mean, the usual thing would be to finance a company from retained earnings and I suppose equity, but debt finance is tremendously advantageous to the shareholders because of the power of leverage. In a sense, if you fund the company with debt finance, then because of the fixed capital return to creditors, you're able to take the advantage of the entrepreneurial harvest. So the more money the company makes, the better for the shareholders. And in fact, the shareholders therefore have an incentive to engage in risky investments because, in a sense, they've outsourced the risk to creditors. Whatever happens, they are protected by limited liability. The people who stand to lose their shirts are the creditors. And if the investment, so even if it's a high risk investment, but a big payoff possibility, so there's a low probability of a high payoff. Rational actors who have limited liability obviously will go for the investment. So whether we like it or not, debt becomes something of great interest. And also, we now have this idea of de-equity, i.e. the configuration of claims that essentially debt claims which more or less look like equity. So we call them de-equity claims, and usually they become very powerful because of conversion rights and redemption provisions, which essentially give the holders of these claims powers to, in effect, affect the corporate governance of companies. So the traditional model of company law, when it thinks about corporate governance, is to focus on the bilateral relationship between the principal and the agent, right? So in a sense, this is really a vertical relationship between the principal and the agents. So the agents are essentially managing the company and the principal being the shareholders, right? And so company law kind of focuses on that. And we kind of associate the principal with the residual claimants. Therefore, we say that they have governance rights within the company. They are the ones who can sack the directors. So the shareholders are the ones who can sack the directors. The shareholders are the ones who can give instructions to the board with a 75% threshold, right? So in this simple form, we think about the principal as the shareholder exercising governance rights, and the agents as the directors, right, managing the company. And therefore, the focus on corporate governance, or the focus of corporate governance, is to ensure this works well. In practice, what this really means is to ensure that you have a good board that can adequately supervise management. Now, that picture becomes slightly complicated when we consider that the monitoring activity, the corporate governance activity that we're talking about, i.e. how to monitor managers, can be better performed if we enlist the services of other claimants, other people who are not part of this picture. And who are those people? The creditors. So if you enter into a credit agreement, if you enter into a loan agreement, and you grant covenants, you enter into covenants with the creditors, which give them a lot of power, right, within the company. We've discovered, it's pretty clear that those covenants are stronger than a lot of rights that you put in your standard articles of association. If you just think about the extent of financial covenants, I know that in Europe they're not very hot on financial covenants, say, compared to the US and the UK. But if you think about the full range of financial covenants, so you have your representations, the warranties, and then strong financial covenants, you'll see that this exerts a powerful influence on companies. And there was a time, certainly before the credit crunch, where we started having covenant-light loan financing agreements. I think we've basically ended this. So covenant-light would be reduced covenants, right? But now we have more strong form covenants. So the point I therefore make is that if somebody says to me, describe the corporate governance of a company, I wouldn't focus on the usual bilateral relationship between the shareholders, right, and the board. I would say let us look at a more complicated relationship that in a sense involves a horizontal dimension because you then have more people who perform a monitoring role. And who are those people? The creditors, right? So the creditors perform this monitoring role. And therefore, where I'm going with this is to say that from a corporate governance perspective, this is relevant. Some people have described this as the missing lever in corporate governance, right? So, essentially, those would be the sort of reasons why we would be sort of interested in this. And you can see that what I've just done is, in a sense, expand on the very simple reasons I have given. Does anybody have any questions so far? Okay. So here, I start by saying that these two sources of finance actually have a lot in common. And some people would say that maybe the future is to disregard the separation or the dichotomy between equity and debt, because really, where does one end? Thank you very much. Where does one end and the other begin? So we start here. I say both of them have limited liability. I know we never talk about creditors as having limited liability, but I think if a Martian were to come to our planet, one possibility, if the Martian were to choose a legal rule, could be to say that why do we say that creditors should only lose the amount they invested in? Why shouldn't they lose more? Why should their liability be capped at the loss of principal and interest? because presumably that's the same question we asked with shareholders at the very beginning, when shareholders had unlimited liability, certainly before 1855. Shareholders, you know, I mean, if you think about it, if you just think about it, if you say that, if we kind of go back to, let's say, 1844, when the company was formed, the company was formed as a legal person. If it's a legal person, then by definition, you and I, the shareholders, should not have any liability for the company's debts. In other words, there should have been no need for a rule of limited liability, because limited liability is inherent in the notion of separate legal status. Now, the reason why we ended up having limited liability 10 years later through the 1855 Limited Liability Act was because in 1844, the rule we introduced was a fudge. We suddenly said there is a separate legal person, but we then said if that person does not pay all its debts, then the creditor has a right of recourse against the shareholder. So the shareholder did not start out by being liable in the first instance. We basically introduced the right of recourse. So that's how we got to this particular rule. But I'm essentially saying that the very notion of limited liability is one that definitely applies to these two categories of, because it's possible to have framed the rule differently. It's just because we've all been conditioned this way to see it, to say, oh, shareholders have limited liability, but you know, you say the same thing about creditors. They say, well, how, you know? But yeah, and then legally, it's the claim the company creates is what you call a chosen action, right? So it's a chosen action. You know, under our law, rights are either things in action, all right? You know, either physical things or you have things in action, right? So here we have a claim, and that claim could be a claim of a shareholder who seeks to exercise income, capital, or control rights, or that of a creditor who seeks to claim rights of capital return and interest. But technically, they're both choices in action. So you know, we put them in the same box in our taxonomy of property, right? And then they can also both be traded on a public market. So if you, I mean, you can see with the bond issue, the Sony bond issue, the BP one, did you look at it? You know, it was uploaded to Keats. Did anybody look at the Sony issue, the bond issue? Okay, I gather you didn't. But anyways, I did make notes on it. The point I'm making is that in that case, it was a convertible bond, right? And it's basically issued, it's traded, right? So we'll come to that in a minute. So they could be traded on a public market. And then, so notice at this point, I suppose the Martian would not see any difference between a debt and a share. They essentially are the same. And then, you know, when we look at you know, okay, the lawyer probably would say, well, with a share, you have rights in the company, right? Because if you look at Section 33 of the Companies Act, it talks about shareholders being party to this Section 33 contract. It doesn't say creditors, right? It doesn't say creditors. And therefore, you could say, well, you know, shareholders have an elevated status. They're the ones recognized within the radar of company law. But I could turn around to say, okay, so who appoints directors? Is there any rule that tells us, if you're so elevated as shareholders, can you point to one rule in the Companies Act that tells us that you, the shareholders, are the ones who appoint directors? Can you point to a rule in the Companies Act that gives shareholders the right to appoint directors? Right? There's none. There's none. So, and that's why you can create a debt instrument with governance rights, giving them the right to appoint directors. Right? So, does that come as a surprise that company law does not give shareholders the right to appoint directors? Yeah. It's now, don't leave here saying, I also said, company law does not give shareholders the right to remove directors. I didn't say that. I said appoint. Appointment is different from removal. Right? So, so they have a right to remove, right? And you can easily game that right? You could, I mean, company lawyers will always talk about a case called Bushel and Fate, where, you know, you could prevent a removal of the director through the use of weighted voting rights. So it's very easy to game that, right? Just by configuring, you can configure a share and just make sure that on the control side, on a resolution to remove a director, the votes will increase, right? In such a way as to prevent the ouster of the director. Okay, so at this point, we're basically here, we're saying that we see both kinds of claims giving rise to similar rights in the area of corporate governance. And I even go a stage further to say that when you look at a lot of de-equity claims, so remember de-equity claims will be convertible bonds, convertible securities which are a hybrid between equity and debt. Essentially, we're really talking about a debt instrument, right, which has powerful redemption provisions, conversion provisions, right, and then with covenants, right, which give you a lot of power. So I know that if you're a shareholder, you can't intervene in the company simply because you think the directors are not managing well, right? Even if the directors mismanage the company, even if the directors commit a breach of duty, you don't even have an automatic right to sue, right? Because technically that's a violation of the company's rights, and therefore, if anyone should sue, it's the company, not you. And if you're going to be able to sue, you'll need to convince a court by persuading them at not one point, right, but more than one point, to permit you to bring a derivative claim. On the other hand, if you take this creditor claim, which is not a share, and you bootstrap governance rights to it, i.e. financial covenants, talking about maintaining a certain ratio, then that's all you rely on. And you just use this to exercise your governance rights. Likewise, I mean, we've talked so much about the payouts from the corporate treasury. A seasoned creditor would say, well, I'm not going to be relying on Section 831, right? I'm not going to be relying on the rules which talk about a realized profits test and net assets test, because I can make my own rules. I can make, because remember, those rules are about legal capital, right? So those rules are essentially saying you can only pay out from the corporate treasury if you have anything above legal capital plus undistributable reserves. But if you manufacture your own rule, you could say, well, you can only pay out if you do not infringe this particular ratio, which I'm setting. Now, of course, there are problems there, because if the ratios are too tight, then it inhibits the rights of managers to manage the company. It reduces flexibility, right? And the other problem is that if they're too tight, then it also means that the creditor, you see, it's not in the interest of the creditor for management to be very innovative. It's not in the interest of the creditor for management to be a risk taker. The creditor simply wants their debts to be repaid, isn't it? If you're a creditor, you just want your principal and interest to come. You really don't care about whether, if Elon Musk tells you that, well, what I want to do is make a rocket which, fires up and comes back, you're not going to want to use my money for that, right? Use your money, right? So that's the problem with creditors. And so if you give too many governance rights, to the creditors, and therefore your agreements are sort of covenant heavy, then there's a downside. So the problem is, how do you deal with this agency problem? Because notice what we're doing now. We're basically saying that when we think about this from a governance perspective, beyond the sort of simple bilateral relationship between the principal and the agent, we actually have another layer to it, where the providers of credit, either the providers of credit and the providers of equity, are in conflict, right? They're in conflict. The idea basically, so the central agency problem is, we want our managers to work hard for us. We don't want them to incur agency costs, right? We don't want them to breach their duties. That's the central issue. But how do we achieve it when our interests are not properly aligned, right? You get the point. Our interests are not properly aligned because we have different motivations. So here I say such covenants exert a powerful influence on the power of management, and you might want to look at that paper by Whitehead. So I say debt instruments give holders contractual rights that are very similar to the sort of rights that shareholders bargain for. So it is common to find that the holders of debt instruments often have the power to appoint a director and to vote at general meetings of the company. And then here we say shares can be configured in ways that are similar to debt. So remember, now we're looking, so we start with debt, just looking at the similarities, but even shares can resemble debt. And that's why, from a corporate finance perspective, a typical preference share, that is your, when I mean, a typical, the notion of a typical preference share is a misnomer, right? Because you remember, one thing I kept on saying is that we need to look at the rights you create when you talk about preference share. Somebody just says, I have a preference share. What does that mean? The rights need to be specified. But so let's imagine you've specified the rights in such a way that it is pretty clear that it is not equity, right? So it's not equity. There's a cap on the rate of on what you can get in terms of your dividends, your return of capital, no participating rights, and such like. Now, from a corporate finance perspective, that would be treated as debt. That's why if you look at accounting rules, they will treat that as debt. And I remember in one problem question, there was a line there where somebody said, so I think the corporate treasurer of the company said that in trying to apply our relevant rules on legal capital, he didn't use the term legal capital. I think the question was about whether or not they could pay a dividend. And so this hotshot accountant in this exam problem question said, well, let's, because international financial reporting standards basically treat this preference share as debt, then we should classify it, we should act with that classification in mind, right? And therefore not count it as part of legal capital. Did you see? So he was taking, what he was trying to do was take a whole line from the company's balance sheet and saying this is not legal capital. Now, but this must be wrong. You don't seem convinced. I mean, whether or not accountants classify the preference share as debt is neither here nor there. From a legal perspective, it will be treated as part of your capital. We do not call it equity, right? But that's neither here nor there. Because remember when we talked about the different meanings of capital, I said focus on called up capital, right? For purposes of distributions. So if you're trying to decide, can we pay money out of the company? You focus on called up capital plus undistributable reserves. because that's your legal capital. If, on the other hand, you're asking a different question, which is who controls the company, you focus on equity capital, right? So what had happened was that this accountant, in the problem question, to get your attention, in the problem question, saw preference shares and said, hey, this is debt. And because it's debt, because we, the accountants, treat it as debt, because international financial reporting standards treat it as debt on your income statement, therefore we should categorize it differently, which clearly is wrong. So shares can be configured in ways that are similar to debt. The preference shareholder would have a fixed right of dividend, just like interest repayment, and often a right of return of capital, again, just like principal payment, either in a winding up or a reduction of capital. So you can see how they look. And then, obviously, debt instruments, e.g. corporate bonds, can be configured in such a way as to give the holders rights that are similar to the holders of shares, right? And we'll see this in some of the instruments we look at. So securities, so here we're talking about the equity. So securities can be created that are hybrids in the sense that such securities are simply one form of security until conversion. So, you would have seen this on Keats, right? Did you look at it on Keats? Okay, and I did say that don't print it, right? Obviously because it's long, it's about 282 pages. But what I was just trying to do was just identify the key aspects of this document, right? And I'm just gonna flag it up, or rather I flagged it up. And so in looking at it, I just said, always look at why are people issuing this? Why are they raising this money? So what are the reasons? In this case, they're actually raising money to pay off debts, right? Part of it, right? So if you notice, they're raising money to redeem bonds issued by the issuer. So Sony has borrowed money, then they need to redeem this, so they go back to the market to raise more money, and also they want to repay a short-term debt, right? So essentially, that's why they're raising this amount of money. And then the governing law, always important to be aware of the governing law, right? Because for obvious reasons, I'm sure Tennyson has talked a lot about that. Remember, I don't know, some of you were in my corporate governance class, and I was talking about a transaction that not a transaction, litigation I was involved in then, involving JP Morgan, and I was talking about the need for, because it had to do with an escrow account. JP Morgan basically received money, close to $1 billion in an escrow account without asking for a legal opinion. Now, I remember when I treated it, I treated it from a risk management perspective. So there were two questions I raised. One, did this go to the board of JP Morgan, or was it simply dealt with as a normal management issue? Two, why didn't JP Morgan ask for a legal opinion? Because normally it's standard, if you're doing a syndicated loan or a bond issue, you would ask for a legal opinion. So if a country is giving you, well, not that the country did, the country and some oil companies entered into what they call a resolution agreement to resolve a dispute, and basically said, pay $1 billion, at least close to $1 billion, into an escrow account, and then JP Morgan released the money according to the instructions, which you'll be given. Then at least ask this question, ask lawyers, is this feasible? Which they didn't. And anyway, the ruling just came out because JP Morgan had applied to strike out the claim. So I was working on this when I was teaching you, or I'm not teaching you, I don't know if many of you are in that class. But anyway, about 2 weeks ago, the court ruled that we won, right? They couldn't strike out the claim. So the reason the reason I stress this is because of the need to get foreign counsel opinion, right? It's, I know Tennecan would have talked about it in your finance courses, but this, I'm sure JP Morgan would have asked for foreign counsel opinion in a typical syndicated loan agreement, right? Because you're dealing with a client, right? So you're dealing with a company incorporated in X jurisdiction. So it's standard, it's part of the template. But here, they were dealing with a government, right, at the highest level, right? And the Attorney General of the government, who is the chief legal officer, you check this out, the Attorney General of the country, who is the chief legal officer, is saying, this is kosher. You have documents from the president, this is kosher. So, so it becomes very easy to think that we don't need a legal opinion. But a moment's reflection just tells, as soon as I saw the documents, as I said then, you cannot tax without representation, right? Likewise, you can't spend taxpayers' money without it being appropriated. So how can taxpayers' money of over $1 billion just go out without any kind of appropriation? Do you see? So you raise those kind of questions. So again, I'm trying to sort of emphasize this. The case is reported, I think reported about 2 weeks ago. If you check Bloomberg, Reuters, it's also mentioned. Okay, so conversion rights would be mentioned, and also adjustments to conversion rights. Right, so the adjustments to your conversion price is important because many of the things we dealt with in corporate governance, corporate finance, equity, become relevant. So the point here is this: if you have, you have a conversion price, what are the things that could affect it? So here, what has happened is the agreement tries to identify the kinds of things we've dealt with that could affect the price. So, for instance, a share split, a subdivision of shares. Remember when we started, we talked about a share split. Remember the example I gave where I think we're trying to deal with a share price which was below. The share price was below par, and in order to rectify that problem, we did a subdivision and a consolidation, certainly with the deferred shares. Remember? Okay. And then capitalization of profits. So here that's section 610, where we move things from your profits. You take a profit from your P&L and move it to your share capital fund, right? And issue bonus shares. Remember, we talked about this on the EIC case. Remember? You're not sounding like you remember the EIC case. But if you look at your seminar sheet where we talk about share premium accounts, you'll see this. And then obviously, capital distribution. Of course, when you see a term like capital distribution, you should know that that has not been phrased well. What they really mean, because the technical term, when they say capital distribution, you'll be thinking about a return of capital. But here, what they really mean is every return to shareholders. Because notice they said, including extraordinary dividends. A dividend cannot be a return of capital, right? So if a dividend is extraordinary, i.e. imagine a special dividend, it still has to come from profit, right? All you just want to do is not establish a dividend history, an unsustainable dividend history. But the point is that that money has to come from profit, isn't it? Right? So if the company has a share capital of £1,000, a share premium account of 200, so 1.2, and the company has in its treasury box 1.5, we know that it is 300. The way they've phrased it there, capital distribution, you think that they distributed everything, right? So I'm just trying to bring in some precision, right? Rights or warrant issues. Remember at the very beginning of the course, when we talked about shares, I talked about the difference between a share warrant and a share. Remember, a share warrant, go back to that early seminar, I think seminar 2 or 3, where we talked about shares, and I said, you know, a right, when you're given a right to subscribe for shares, right? And then modification, and then issues of shares at less than market price. Again, we dealt with this. Remember when we, you know, so if the market price, so yeah, we're not talking about par. We're not talking about par because that is unlawful to issue shares below par. So what, you know the case here, what's the name of the case here? Reholders. Remember there's a case called reholders, which basically say that if you're going to issue shares at below the market price, then the directors need to establish that there's a business case for doing this. And I think we tested this in the context of a problem question where, remember there were some problem questions where it was below, but the business case we supplied was the entry into some kind of joint venture type arrangement, a strategic relationship, I think that was how it was put, right? And so once we could say that there was a business case, then it was fine. And this had nothing to do with the power rule, right? And then obviously change of control, all right?
May I ask a question?
Please do, yeah.
In relation to that case where we talked about a subdivision followed up by a consolidation in where you ended up with a lot of deferred shares. In that case, there was no adjustment, right? Because the market price remains the same, even though you changed the nominal value of the shares. Or would that also trigger an adjustment?
No, the market price obviously will not change, right? So the market price will not change. If you go back, I think it was initially, what changed was the par value of one type. So initially I think it was 0.01 to 0.1, right? And then then you had the deferred share. So the market price is the market price. That's not changing. That's just a function of the market, right? It's essentially the real change there. If you go back to that seminar note, if you look at the seminar notes for that, and I think the next seminar, you'll see that I actually put in an explanation just so that that bit was clear. That events of default would be, again, in this, you'll see this in every sort of capital raising agreement, whether it's a loan agreement or a bond issue. These are standard events of default, you know, non-payment, breach of other obligations, cross-default. I'm sure you guys have talked a lot about cross-default, you know, the sort of pros and cons of it, insolvency, illegality. You know, illegality is always a bugbear because there are too many things that make things illegal, right? And so it creates, you know, a friend of mine actually wrote a book on illegality. So for a number of years, we're always talking about the illegality, you know, how these things are. And every time we meet, I almost assumed I was writing the book myself. So it's that tends to be an issue. So for instance, one area where this could manifest is in regard to capital controls. I mean, recently you had Iceland, Ukraine, introducing capital controls. Some people are saying that if Brexit goes pear-shaped, there may be capital controls. Certainly the Chancellor, the Shadow Chancellor of the Exchequer has said that he will introduce capital controls. Now that would be monumental because the last time we had capital controls was in 1979 when the Thatcher government came. So the Germans were the ones who introduced capital controls in 1917 after the war, and then France followed Europe. Then later, America came up in 1921, but then it was phrased as if it was dealing with, trading with the enemy, right? And in the UK, we had rules which were similar to the US rules in 1939, but certainly by 1947, we passed our Exchange Control Act of 1947, and that kind of continued till 1979, when it stopped, but a formal repeal occurred in 1987. So although capital controls ended in the UK in 1979, the formal repeal was in 1987 in the Finance Act. But the point I am making is this. Because capital controls, if you infringe them, they give rise to illegality. Do you see? They give rise to illegality, then that's a problem. Now, we don't even need to make it. The country of the borrower, right, could be the one. And then if the country of the borrower introduces capital controls, then under the Bretton Woods Agreement or the IMF Articles of Agreement, we are obliged to recognize it if it is lawful under the Articles of Agreement of the IMF. So what this means is that if a company in Lithuania or Poland or Africa, anywhere, enters into a bond agreement to raise money, and the country subsequently passes some kind of capital control rules, then potentially you have a problem of illegality. Now, the question would then be, will your jurisdiction recognize this illegality? Now, because under the Articles of Agreement of the IMF, there is an agreement that capital controls will be recognized globally if they are what you call an exchange contract that IMF rules allow, then the capital controls, the illegality of it, will have extraterritorial effect. It means that our jurisdiction will have to recognize it. And what does that mean? It simply means that the agreement will be unenforceable.
By capital control from exchange control?
Yes, that's right. Yeah, precisely. So I'm happy you pointed that out. So capital controls is even wider than the term exchange controls, where it embraces that. I'm even impressed that you know it, because most people don't know. Oh, he did. Oh, good. Because you see, when the Shadow Chancellor said to the Young Labour group, that he will introduce capital controls to deal with Brexit and all that, and they were all clapping for him. I'm thinking, these folks don't really know what this is about, right? This is, in my mind, I'm just thinking this. And then a few days later, the director of the Adam Smith Institute, and I'm sure the name of the institute gives a clue about where they stand, right, wrote a comment in the Times and said, unless you are above age 45, and I want to assume you've not reached that age, unless you're above age 45, you really won't have a clue. But once upon a time, to travel out of the UK, there was somewhere on your passport, apparently the last page, where you'd kind of declare how much you're taking away, and you couldn't take away a certain amount and all that. And it made criminals of so many people. So do these folks know what they're talking about? But anyway, so that raises issues of illegality. And initially we kind of, after the last credit crunch, we've seen a resurgence of capital controls. So Iceland, as I said, Ukraine, and there is a feeling that this could become more prominent, right? As a kind of almost anti-globalization thing. in a sense, the whole debate on this really goes way back to even when we had the League of Nations. Right? So the League of Nations was reacting to capital control, saying, "Oh, this is bad. It's a strangulation of trade." So there's nothing new here. Do you see? I just think it all depends on which side has ascendancy in the debate. Right? Okay. Now, and again, in terms of the whole capital structure, then we'll talk about the dilutive aspect of convertible bonds, because that's a point I pick up in the BP one. I even put a note there, so you'll see that. So let's get back to capital structure. Does anybody have any questions so far? Does anybody have a question? Okay. Sorry, okay. Okay. So we want to come back to capital. Actually, it's 11, so we'll take a 10-minute break, and then we start with capital structure, right? And go on. Okay, so 10 minutes. Yeah.
Yesterday in our convertible bonds lecture, how you made a distinction between capital distributions made just before conversion and whether you're entitled to it after conversion.
Entitled to what?
Entitled to the distributions made to shareholders. I think you said some sort of record date, and if the conversion was made, maybe it's after record date or something like that, and you aren't entitled or you are entitled, something like that. And then you also spoke about interest payments, dividend payments. I was got a bit confused because when you say capital distributions, that was dividend fall within that, right?
Yeah, so why not? In fact, the best thing to do then is, have you looked at the Sun one? The Sun means?
No.
Yeah, because everybody writes what's you look at the. I'm even happy Rafi mentioned it. If you look at the Sun, it's on Keith.
Okay.
And look at the particular section of highlight and just see how they treated it.
Okay.
Yeah. Do you see? Yeah.
All right.
Yeah. When you were dealing with it, did you have a bond? Did Rafi give you a bond issue?
No, it was just going through the law, what the terms that would be in the
Yeah. So look at that, because that's. I mean, here you have a tweet page, and everything is there.
Okay.
Yeah.
All right.
Okay. Yeah. Let me quickly get a copy.
Discuss about the red line of my paper.
You know something? I was coming. When yesterday night, I remembered that I hadn't dealt with it, and I'm really sorry about this, because I got, sidetracked. So I will be getting in touch. I'm going to the office, that is the office dealing with this this afternoon, and I will pick this up with Delphine.
But
Right?
anyway, you can assure me that it won't be the 22nd.
No, it won't be. It won't be. That's what it will
And
be.
when it will be? In the end of
It will,
March?
yeah, it will certainly not be the 22nd. It will be much later.
Will be much later.
Yeah. So, because your problem. So, what we want to do would be to make it much later. I'll look at them, but definitely not the 22nd of March. It will be later.
Yeah, but I think it won't be. It will be still in the end of March, beginning of April.
What's the preference? You wrote it.
Actually, now I'm studying for the paper, so.
What the email you wrote? What was the preferred date? Did you put the preferred date in the email?
Yeah, I wrote in the end of March.
The end of March.
Also, because basically then I have an exam the 10th of April, another the 23rd of April, and then the beginning of
So
March.
end of March. Yeah. Don't worry, what's your name again?
It's Francesco Carelli.
Okay, it's Francesco. Okay.
Yeah.
Don't worry, you'll get to me. I'll deal with this afternoon. So I'm going to go to the office. I need to get a coffee.
Just the last question. On the paper, I put the abstract.
不是，就是人家政府是不会提供给那个项目。所以以后啊，这个以后那个注册是可以不怎么收，现在收一个，那时候在收，以后反正把那个出生号那个费用这样的话，万一以后做出那个多，我们就注销掉，对不对？没关系，那我们下一个怎么样？注销掉吗？
with a round brush. Our land is trying she says she has supposed to take 4 weeks back. I think it's just not even like we should exchange it just because it's and if there was当年如果到了，那不用了，人家就不租了或者怎么样，然后你这个对应的那个什么，这个东西如果没有了，以后不知道会怎么样，这一直放在那我们很清楚，就是一个从如果3月4月开始不管这个事，然后后续的这个事情，第二种方案就是那包括他们自己去获取这些，第二种方案就是他出来这个然后把这件寄过去，那个找到或者怎么样，那 第二个你随便他去。如果他不愿意出高点分，那么他肯定是把自己就后方那边你看前面要么就这么两个，还有没有其他人觉得还
But I think we can so much with our deposit. I think I paid 3,600. It was 2 months plus so I think
就是老汉就是
even though he said
这哥们儿有点困难。
like that, so you can do But I'm on my way. No, I will say. And also at the end I won't pay for that's how I get it.
就 所以你不用说那我可以。
Yeah, so so we come back to excuse me, we're about to start now. So we come back to capital structure, and remember when we dealt with capital structure, we looked at it from a sort of legal and finance perspective. From a legal perspective, we need to know what it's about, which is it's legally the relationship between equity and debt within the company's financial structure. So when we say legally, we concluded that the legal implications would be in regard to undercapitalization. Remember, we talked about undercapitalization. So if you undercapitalize a company and you have lots of debt and your gearing pushes you into insolvency, then you could potentially be liable for wrongful trading, disqualification of directors, and in this regard we talked about the possibility of even piercing the corporate veil using cases like re-FG films. If you go back to your seminar, you'll see that we talked about re-FG films, and I then said that was really an old way of doing it. That when you look at cases like Petrodel and Prest, the courts are not likely to use piercing the veil simply because you undercapitalized your firm. I did say, however, that it could be an indication of wrongful trading, right, under Section 214. And if that is the case, then there will be personal liability because you'll be subject to a contribution order. And I also said that if that's the case, then you could also be potentially disqualified as a director. There was a case called Re Austinet. So if you check your seminar pages, then on the legal consequences of undercapitalization, I discussed this. Now, the reason I'm mentioning this is that if somebody says to me, what is capital structure from a legal perspective, right? It has to be that, right? That relationship from a legal perspective. And also the tax element, right? Remember, we say that if you have an undercapitalized firm, the taxman may decide to treat the debt component as equity, right? And the Americans have this thing called equitable subordination, where they recharacterize the debt as equity, right? Because that's the only way to protect creditors. So you have a company, right? Try and imagine a parent company sets up a subsidiary. The parent company could put in equity into the subsidiary. It chooses to put in nominal equity, so maybe £1, and then loads it with debt. Now, if that company then borrows money and the company collapses, the parent company, right, is above the pecking order because it has debt. But the parent company can control the subsidiary through its voting powers. So the courts would say, well, we know what's going on. What you've done is undercapitalize the company, in order to promote yourself. Therefore, we will subordinate you. That's why it's called equitable subordination. We will subordinate you to rank below the creditors. So to rank below the creditors that you've basically configured, which is yourself, right? So we'll essentially treat it as equity. So that's the only consequence of this relationship from a legal perspective. So notice I'm talking about consequence. Then the other legal aspect is who controls capital structure. You see, so one form of the question is, what is the legal consequence of capital structure? If I see a question, if somebody says to me, what is the legal consequence of capital structure? I'll be thinking about the points I've just talked about. And if the question is, who controls capital structure? I'll then be thinking about Section 551, right, which deals with the rights to authorize the allotment of shares, preemption rights. Remember we talked about this. In fact, there's a section there, control of capital structure. Now, notice what I'm doing. I'm simply trying to provide a legal answer to capital structure issues. But there's a finance dimension. So if you're talking to somebody in the London Business School and he's talking about capital structure, he's not going to be talking about these two things. He's going to be talking about Modigliani and Miller, right? Which is the capital structure irrelevancy theorem, right? To say that, his point would be that, well, capital structure doesn't really matter. Whichever way you arrange things, you can't really change the size of the pie, right? Whichever way you arrange things. But if he's accurate, he would say, well, in a perfect world of costless, in a perfect world where things are costless, there are no taxes, blah, 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 right? You can't change it. And if you say to him, well, the world is not really that perfect because there are taxes, and if there are taxes, then the tax shield will affect your debt weighting. I mean, if you do the calculations, if you just on a spreadsheet and you're trying to calculate your WACC, you will always see that the effect of the tax shield on debt changes the picture, right? So that's the way this question is dealt with, and I just thought it's important to be aware of it. So that the reason I'm trying to emphasize this is that if you pick up a finance journal and somebody's talking about capital structure, you need to understand where the person is coming from. If you pick up a legal issue and they talk about capital structure, in most cases in law, they're not going to talk about capital structure, right? Because if you notice, if you go back to those things we dealt with, they never phrased it in terms of capital structure. We were the ones who brought it in and gave it that title. Instead, what we do in company law would be to talk about piercing the corporate veil, and then we throw a number of cases and we add re-FG films. And when you read re-FG films, the court says, well, undercapitalization is a ground for lifting the veil. Or you talk about equitable subordination. So all we've just done is take those cases and say they're about capital structure. Likewise, we went to share issues and preemption rights, and again, we say it's about capital structure. Now, I'm saying, therefore, that we can continue with this narrative from a legal perspective by looking at the role of creditors in capital structure decisions. Because we would be mistaken to think that creditors don't have a say. Right? Creditors do have a say in capital structure decisions. For instance, a typical bond instrument would lead to dilution, right? And that's why, certainly as from 2014, we began to see what they call non-dilutive instruments being issued to counter that. So if you check, let me sort of highlight this bit here. So you can see here, I say that a convertible debt, by definition, has a potential dilutive effect. This is because the debt becomes a share. Remember how the debt becomes a share? The release of a claim for a liquidated amount, right? Isn't it? That technically becomes payment of shares, right? So the company will have to issue shares to the holder of the debt, who releases the liability of the company for the liquidated sum. So if you look at Section 583, Section 583 talks about how we pay for shares in cash, right? Remember, I always say all these provisions look like mechanical, they're different things, right? But in corporate finance, we apply them, right? Just so that we're all on the same page. So I'm just saying, when we looked at payment for shares, we're just looking at it technically. How do you pay for shares? Money or money's worth, right? Then we looked at what is the definition of cash. Only lawyers will define cash, all right? What is the definition of cash? And then we see cash is cash. Cash is payment in the future. Cash is the release of a liability for a liquidated sum. So if the company has issued bonds, and therefore the company owes me, the bondholder, and I then say, I release your liability, then technically I have paid for shares, isn't it? So that bond becomes a debt. Sorry, that bond becomes a share. Remember Mosley and Coffin-Tan mines. That's the structure. Remember, the only problem with Mosley and Coffin-Tan mines was that it's then converted below, the debt itself was issued below par, and then when it converted to the par value of the share, right? That's the only problem. So, now, I say here that the issue of more shares will therefore be dilutive. And if it's dilutive, you're changing capital structure, isn't it? You're changing capital structure. So I then point to, I said the solution to this particular problem is to ensure that conversion rights are cash settled by reference to the share price of the company. So this would involve having a hedging instrument. Sorry.
What do you mean by the cash settled?
Essentially, it would involve using a hedging instrument. If I'll try and send you, I'll look for some examples. Certainly, there was the Vodafone one, and I think there was also another one involving Telefonica. So essentially, what will happen is that the company would have to enter into a structure whereby the price payable on the bond on conversion would be based on some weighted average price of the relevant security before conversion. So it's going to be tied to the underlying shares. And essentially what will happen is to enter into some call option to hedge. What I'll do is, let's look at the BP one if it describes it, the mechanics. But basically, essentially what you're trying to do is give the shareholder money. That's essentially what you're trying to do. You're trying to give the shareholder money You're saying to the shareholder, or rather the bondholder, I don't want you to become a shareholder.
So that it means the client would redeem these convertible bonds.
Yes. So essentially, now if you leave it as it is, so in other words, if you don't cash settle it, technically, the bondholder, right, will become a shareholder. What you want to do is find a structure to prevent this. And if you use this option, and actually you would use options, as the case may be, if you do it, the bondholder will end up with cash in his pocket. And if he ends up with cash in his pocket, he's no longer a shareholder. So the structure by which you end up with cash in your pocket, referenced to the price of the shares, is what we talk about. And you'll see this in the BP. Let's turn to the BP bond, the BP issue. Okay, I think I put that under further materials.
Is this solution very common in corporate finance? Because it's a bit contradictory to what we have learned in bonds with RA, because here is the issuer who has to give notice to the bondholders before redeeming, and then they get the chance to convert.
It's non-dilutive bonds first emerged recently in 2014 and you're entirely correct. It emerged as an alternative to your typical convertible your typical conventional corporate convertible bond, so it's a new thing. We're talking about 2014, and indeed that's why I thought to give you the example of the BP one. So essentially, what it does is to provide you with the opportunity to capture the pricing benefits of the bond over a straightforward debt issuance, but at the same time avoiding the dilutive effects, because that's really the problem you will face with this. You will have a dilutive effect. And I know that Vodafone did this. Vodafone did it. Telefonica, and then the BP one. So let's look at the BP one, for instance. Okay, so here we have, through a structure combining the issue of guaranteed, non-dilutive, cash-settled convertible bonds with the purchase of cash-settled call options to hedge the economic exposure, right? And then it says, as the conversion rights in respect of the bonds will be cash-settled by reference to the share price, the issue will not result in the issuance of more shares in BP. Remember, I said you would need to have a hedging structure, usually through an option. And then, let's see. So you will need a hedging instrument. You need a hedging instrument for this purpose. So essentially, the point is, remember, the bottom line is this: you want to find a structure that gives the bondholder cash, right? Because the bondholder, you don't want capital structure to be affected. If the bondholder gets shares, then the capital structure is affected. You're just trying to imagine the effect of this on your capital structure if all the bondholders or at least a substantial part of them, get shares. And so what you're trying to do is find out a way to get cash into their pockets. But that's the easiest bit. The issue would be how to track the price and to make it to make it a fair one. Essentially, so you'll be looking at the conversion period. What are the conversion events? How do you take account of some of the things which could affect this formulation? So things like an early redemption, things like the payment of a large dividend, because the payment of a large dividend could also affect things like change of control issues, some of the things we talked about earlier. So yes, you're right, it's not the conventional one, but the whole idea basically is to give people more flexibility.
Who are the parties to the option? Who would be the parties to the option?
Obviously, you would, if you're writing an option, it would be a third party. So like any other option, right? Because you're basically asking somebody.
So it's the company that the issuer that will then.
Yeah. Okay, so here we now deal with debt financing, an overview. I'm not going to, presumably this is straightforward, right? I'm not really going to talk about this because it's, I'm assuming you've read it and it's pretty straightforward. So what I just want to do is skip over that and talk about the doctrinal foundations very quickly, and then, because I think these are the two key bits here that guide our thinking to these structures. And so the typical way the English lawyer who has thought about these things operates is to be very clear about the sort of the foundational principles. So the foundational principles in English law is party autonomy. So we don't start out with a restrictive approach. We allow you essentially to write your own contract. If you like, call a dog a cow, whatever. Okay, there'll be a bit, some limits, right? Some limits, but basically, we allow you to do whatever you want to do, right? Within limits. Now, other legal systems do it completely differently. And so people will always say that one benefit of sort of common law is the inherent flexibility built into it, right? So this is why I'm interested in the limits to party autonomy. So if you don't mind, let's talk about the doctrinal foundations briefly and segue into party autonomy and its limits. And then we come to the functional issues that I've identified here, because those are the functional issues that we need to deal with. So the doctrinal foundations will be contract, right? Some cases, property law comes in, especially when it comes to granting security. And when property law comes in, that's where you see a limit to party autonomy, because property law is made by the state, not by the parties. You get it, right? So whatever you and I can do as a matter of contract, fine, but there is a limit to how far we can go when it comes to property. Many years ago, I wrote an article called "When is a Cow Not a Cow?" And that was because, and I wasn't being facetious. What had happened was that an arbiter had received cows from the seller, and the cows had been killed, and there was a suspension of the passing of title through what we will call a Romalpa clause, a retention of title clause. So the liquidators of the company, the arbiter, seeing the carcasses of the cows, and not any one had been eaten yet, right? So the cows were just freshly killed, right? So they were very valuable. So he sought to take them. And the supplier of the cows said, well, you know, those are my cows. And the liquidator says, sorry, they're no longer cows. You know, and so this goes to court, and the judge says that you know, yes, as a matter of property law, as a matter of contract, you can retain property in your cows, but there is an inescapable difference between a dead cow and a live cow, right? And in other words, the court is saying that there has been irreversible change, and that must be correct, because I've never heard of a resurrection of a cow and all that, right? So there clearly had to be irreversible change. And this kind of goes way back to Roman law, where, you know, the Roman law had to contend with what happened when, you know, you gave somebody whose job is to make bags, so you give him the skin of an animal to make a bag, and he then makes a bag. Has there been irreversible change? You know, because the point is that if there's irreversible change, then there's a new property, and therefore your contract is incapable of dealing with this new property. So you can see the limits of contract law in asserting property rights over this new thing. Now, this then becomes a big issue in financing, because if you grant, if you try to create a legal outcome that the legal system thinks is not possible, then you see the legal system recharacterizing it. So we see this in the context of a security, like a fixed charge and a floating charge. So, you know, for a number of years, the banks loved fixed charges. Because a fixed charge, you know, let me start with a charge. A charge is a proprietary interest, an interest in property, right? So let's make it very simple. If you know, you know, if I give you a loan to buy a house, and you buy this house, presumably you own the house. But if I say that I want an interest, a proprietary interest in that house until you pay me the loan, then I have a charge, right? So that I have a charge, and the technical term would be I have a fixed charge, right? Because it's just there, right? So it's a fixed charge. And that means that my interest is a proprietary one. It's superior to your other creditors, right? Because if you have creditors, I would be on top of them, because I would always say, like, you know, this house belongs to you. At least to a certain extent, this house belongs to me, right? That's what the company was doing in this case. The company would supply the cows. They're saying, the cows belong to me. You, Mr. Liquidator, you can't take it. So that's why there was an argument about whether the cows were still the cows. But in this case, the house is still the house, right? So there's no problem there. Now, if, on the other hand, I give you money and I say, all the assets that you have today and that you may have in the future, and your assets are constantly changing, I have an interest in this, then it's technically a floating charge, right? Because it's constantly changing, right? It's a floating charge. Okay, so now we know what a charge is, and we know that you have a fixed charge and a floating charge. The next thing to know is that the law places floating charges over at a disadvantage, because if a creditor steps in and says to the debtor, yes, there's a floating charge. The debtor would say, well, you know, I have employees, I have other claims to pay off, right? So like employees have a preference. So technically your charge becomes a bit inferior, right? Because before you realize your charge, the debtor would need to pay off other people, right? So if it's a company, the company goes into insolvent liquidation, the company would have to, in a sense, pay off its workers, right? Their back wages, their pension, whatever, pay off those workers first before the bank can realize its security. And when you think about employee entitlements, this is a lot, right? And even pay off the expenses of the insolvency practitioners. And that's also very, you know, it's a lot, right? So no bank wants to be in a position of having a floating charge. Every bank wants to say, I have a fixed charge, because you know, when you have a fixed charge, you're not concerned about these things. You just go there and take the asset. So the question then is, can we by contract call any security we grant or we create, can we call it a fixed charge, right? If the law allows you call it a fixed charge, then that's party autonomy at its highest, right? Because that means you're using your rights of party autonomy, right, to create a property right that you're saying the law has to respect. Do you see? So the question then is there a limit? Is there a limit to this right of party autonomy? So let's look here. So here we say the relationship between property and contract also raises a question as to whether there are limits to the use of contract law to secure proprietary rights. Are there limits to the use of contract law to secure proprietary rights? Can I, by way of this agreement, say that I have a fixed charge when technically it looks like a floating charge? So what are the limits? Well, the law basically would say that there are two limits. Remember now, English law places very few limits. So we start from a position of freedom of contract, but there are two limits here. One limit would be that of legal consistency. So we come back to the example of calling a horse a dog, or calling a dog a horse. So imagine you draft this contract and you say, this thing, which is a dog, is a horse, and you use equine terminology throughout, you know. And then, do you think the court will listen to you? Because if the answer is yes, then two things are going to change in the examples I've just given. One, in the cow, when it's a cow, not a cow scenario, you could put in a clause there in the contract to say, and for present purposes, a dead cow is the same as a live cow. Right? You could say that and expect the courts to enforce it. Likewise, the bank, which has drafted a fixed charge, which really is a floating charge, could also write, for present purposes, this should be construed to be a fixed charge. So, the challenge you will face is whether the courts will pursue legal consistency to say, you know something, we know what a fixed charge looks like, and we're not going to allow you change. And also issues of public policy. So issue of public policy would be, in the case of the fixed charge floating charge, would be issues of the claims of employees. Because if you say this is a fixed charge, then what you're really saying is that the employees don't get paid. Yeah.
But the corporate benefits question is outside of this.
Yeah, the corporate benefits is entirely outside, right? So, so the corporate benefit question would be a question that, and I'll define what a corporate benefit question is so that everybody's carried along. The corporate benefit question is a question that we would have to ask, when we look at the legal issues that the corporate borrower or corporate lender has to be aware of or consider before entering into this kind of agreement. Right? So let me give the example to illustrate what corporate benefit means. So you have a parent company, you have a subsidiary company, right? And then this subsidiary borrows money from a bank, and that money is going to be sent, all of it is going to be sent to the parent company. Or a company X, company Y are sister companies. Company Y borrows money and sends all the money to company X. Now, if the bank is entering into this, the bank has to ask the question, why is company X borrowing? What's the corporate benefits? What are you gaining from it? Why are you borrowing only to send it to company Y? Right? And you know, English company law does not have a concept of the group. We look at each company, not the group. We only talk about the group for purposes of accounts. Right? So when we do filing of accounts, we say, you know, group. But really, we look at each company. So corporate benefit will be a question you need to answer, right? And we have a lot of cases here. The leading case is a case called Rolled Steel, right? The Rolled Steel case was a case where the court said, this is a question you have to ask. Now, that's not what we're dealing with here. What we're dealing with here is a narrower question. It's a narrow question about security. It's a narrow question about whether you can use, by means of contract, call something different, and whether the legal system would respect it. Right? So, here I say that the doctrine of party autonomy entails the consequence that parties are free by their contract to produce desired legal results or outcomes, but the courts will stand ready to ensure that the law continues to retain its internal consistency. So a cow does not become a dog, right? A floating charge does not become a fixed charge, no matter how much labeling you use. Likewise, considerations of public policy may require the court to place limits on the contractual effect of instruments, right? And the process we set about doing this is a process of recharacterization. So in commercial law, a big issue in corporate finance is recharacterization. When people talk about recharacterization risk, that's really what we're talking about. We're talking about the risk that you write one thing and the judges construe it to be something else. Right? So you want to avoid, you want to avoid the risk of recharacterization. If you're coming up with a structure, right? Remember I always say, if you're doing any corporate finance transaction, right, you need to have like a cross-check, right? And I remember I emphasized, I said, financial assistance must be there, right? So anything you do, no matter how far removed it is from a purchase of shares, just make sure financial assistance is there so that you can come back and just look at it and say, okay, this morning I'm going to look at this transaction only from the perspective of unlawful financial assistance, right? Because it can be a big problem. Another cross-check you should have is the risk of recharacterization. Everything we're doing, can it be recharacterized? Remember when we did return of capital, right? Remember when we did it? There was this tax case, right? Which basically changes the way you approach, for instance, a B share. Remember? And we looked at it, right? With a view to assessing the risk of recharacterization. That's exactly what we're doing there. Likewise, in the other case of Mosley and Covington mines, you see the court recharacterizing. Okay? So, but even recharacterization has a limit. So look at what Hoffman says in BCCI. So this shows you the superiority of English law. He says, in a case where there is no threat to the consistency of the law or objection of public policy, I think the court should be very slow to declare a practice of commercial community to be conceptually impossible. The law is fashioned to suit the practicalities of life, and legal concepts like proprietary interest and charge are no more than labels given to clusters of related self-consistent rules of the law. So don't be quick to say, well, this looks like a legal impossibility, let's strike it down. That's really what he's saying. So I say here, consider the case of LI10. Now, LI10, when we talk about consensual security in English law, we talk about the charge, the mortgage, right, the lien, right? So lien is one of them. It's a consensual form of security known to English law, and it applies to tangibles, you know. So you take your car to your mechanic to repair. He has a lien on it if you don't pay, right, on this tangible. So what if the parties draft a contract which purports to create a lien over intangibles? Right? So the law says you get a lien over a tangible. These guys have drafted a lien over an intangible. An intangible only exists in our minds. It's not something you can hold. Right? So can you have a lien over a concept that exists only in our minds? Somebody would say, well, this is impossible. Right? But the courts are saying, no, impossibility should not be the answer. And so here we see this. So if you look at this clause, and this came from Lehman, you see the clause said, the client agrees that the custodian shall have a general lien on all other property, right? So when you read it, they were creating a lien over an intangible. So what does the court do? Now, you could say it's impossible, or you could say that, right? So does the clause create a general lien? And if it's so, does it apply to intangible property? Right? And I say, if the contract is deemed to have this effect, it would distort established legal principles. And I say, and so what? We live in a world of disruption. But you know, there are people today I went to a conference in Mexico, and there are lots of not from Mexico, the academics, but they came from like Europe, and they were all against Uber. And I'm thinking, what planet are these guys from? You know, how could they be against a free market thing? And you know, but anyway. So guess what? So some people don't like disruption. Or is it probably characterized as a charge? Right? It would be a charge if we say that I have the property, right? And I confer an interest on you, which you hold as security, right? And my ability to redeem my property lies in my power to repay what I owe you, like the mechanic, right? Right? Or is it to be characterized as some other form of security interest? Now, but if you look at the judgment in the case, you'll see that the judge basically comes to the conclusion that it's a charge. He comes to the conclusion it's a charge. If you look at the last two paragraphs there, you see he works his way. So notice he doesn't say it's impossible. He puts it within the appropriate legal category because, you know, you have an interest. Remember, a charge, I have property. I confer an interest on you, which becomes defeasible on payment. It ends on payment. Technically, it's an equity of redemption. So you redeem it by paying, and that's it. Now, obviously, if it becomes a charge, then you have a problem of registration because you should have registered, right? So those are the kind of things that you need to be aware of. So so we come back to the question he asked about corporate benefit, because when we deal with issues of the things we need to consider when going into these agreements, we need to consider the risk of recharacterization, corporate benefit, registration. So if you look here, the corporate benefit question, right? The risk of recharacterization, right? Number 5, perfection of security. If they didn't register it, then it's not perfected. So whenever you're thinking about entering into these agreements, these are the sort of issues you need to consider, right? And just kind of work your way around. So I'll stop here, and obviously when we look in the next class, when we begin to look at the bringing it together in the context of a real life type scenario, we'll go back to many of these things and apply them, right? Okay then, thank you.
Did he recharacterize it from a lien to a charge?
Yes.
Okay.
So it was recharacterized. It's basically, yes, yeah. So they recharacterized it to a charge. They didn't say it's impossible. Maybe a civil lawyer, a civil judge would say it's impossible, right? We said it's possible, but you would have to register.
So was it then void because it wasn't properly?
Yeah. So because okay.
With that case about the cow, if there were Amalfi clause that said protection charge as a cow, anything following from the cow, would that then be invalid?
No, it will not be because.
So it can't contemplate the cow being dead.
Yeah. So it won't be because the court will say actually what they're trying to do is create a charge. Because you think about it, assuming. Because if you say that's the case, then what if you have enhanced the value of the cows? You get cows, and then they go 3 times the value. Then that means you use this clause to catch it, and then you get a windfall.
I can't remember what I remember.